we have a problem, which I'm trying to address, and I will address, by limiting your cross-examination.
The judge steps in, telling prosecutor John Lewin, pick up the pace, as Robert Durst gets ready to spend another day getting peppered on the witness stand. The R. Kelly trial continues this morning in New York. A former studio manager expected back on the stand. We're live in Brooklyn. And the Attorney General on trial for hit and run. He agrees to a plea deal on the eve of trial. We have the interview he did with police after killing a man and driving away. It's all next on Court TV Live. Good Thursday morning, everybody. Welcome to Court TV. I'm Ted Rollins. Today marks day 7 of testimony in the federal sex trafficking and racketeering trial of singer R. Kelly. Court gets underway in about 30 minutes. The prosecutor plans to continue direct examination of Kelly's former studio manager, Tom Arnold. The prosecution accuses Robert Sylvester Kelly of heading up a criminal enterprise that lured women and some underage girls and boys into his entourage for illegal sexual activity. Kelly denies the charges and says that the women were fans and groupies who were willing participants. The jury on Wednesday heard more powerful testimony from one of Kelly's accusers, Jane Doe number 5. Court TV legal correspondent Julia Janae is in Brooklyn, New York, covering Kelly's trial for us. She has more from outside the federal courthouse, where jurors will arrive in just a few minutes. Good morning, Julia.
The last witness of the day on Wednesday was a former employee of Robert Kelly. Tom Arnold said that he worked for the singer for many years, and one of the rules for when he would pick up female guests for Kelly was that he had to turn the rearview mirror up so that he wouldn't make eye contact with the ladies. Arnold's testimony took this jury inside of the Chicago recording studio, one of Kelly's recording studios that was stocked with control rooms, but also full bedrooms. Outside of the courthouse, sidewalk art support echoes the sentiments of pro-Kelly spectators inside.
The evidence shows that he's innocent. He didn't do all these crimes and everything, that's tainting him. And so we just believe in the evidence. Yes. And we know he's going to come out okay.
Court TV spoke to co-founder of the hashtag Mute R. Kelly movement, Kenyette Barnes. She said they haven't called for any demonstrations of this New York trial due to the pandemic. Barnes said when they first started this push in 2017 to have R. Kelly's music pulled from the airwaves, they expected there was a possibility that charges could follow.
I am familiar with the RICO statute, and I do believe that as an enterprise, that it's an appropriate charge for him because he didn't do this alone. There were runners and producers and drivers and groomers and people who recruited these girls, people who kept them in these rooms, people who fed them, people who told them not to be quiet, people who took them to doctor's appointments. I mean, so these are all things that was happening around him. So absolutely, these people, in my opinion, were acting on behalf of Robert Kelly. And I think the federal process, the federal charge of the federal RICO charge on this case is very appropriate for him.
That direct and cross-examination of Arnold will continue, along with more prosecution witnesses for day 7 of United States versus Robert Kelly. Back to you.
All right, thanks to Julia Janae. Again, jurors expected to arrive at the courthouse in the next few minutes. Testimony to resume at the bottom of the hour. Julia will be in court and provide us live updates throughout the day. Let's bring in our guest this morning, former prosecutor and trial attorney Rosalind Charles, and criminal defense attorney and former prosecutor Doug Chanco. Good morning to both of you. Rosalind, to you first. R. Kelly's case is it's elaborate. The federal government has a very long list of witnesses that are coming in and independently telling basically the same story. The House of Horrors that was this recording studio in Chicago, in a lot of, that's their side. On the other side, the defense is saying, no, this was the recording studio of an artist, and he had groupies and friends and people that wanted to be close to him there 24/7. So far, your take on how this case is going from the federal government's standpoint?
Well, good morning to you, Ted. I'm happy to be here. I think both things can be true at the same time. However, I think the prosecution's case is very compelling, and these charges, indeed, the racketeering aspect of it, are very strong on the side of the prosecution. Yes, they were definitely groupies. Yes, they were definitely fans of his, but it's what he did with these groupies and these fans and the manner in which he went around corralling, if you will, these young girls. All of the individuals that were involved in, if you will, the enterprise. And the object of that enterprise was to not only bolster and support the financial gains of R. Kelly's music career, but they were also to keep that these were some of the things that he liked that allowed him to function. And as ghoulish as everything is, it happened to all traffic, if you will, around garnering young women, underage girls, for his these were his sex toys, if you will. And so I'm thinking at this point, based on the testimony that I've heard, the prosecution's case is looking very strong.
Doug Chanco, the head of said organization has to be R. Kelly, right? And we've seen some pretty aggressive, at least lengthy, cross-examinations so far from R. Kelly's attorneys. Right now, you got a studio manager, also was a road manager for a while on the stand. He's going to endure some more cross-examination today. Do you expect this morning's cross to be pretty intense? Because this isn't a sexual assault victim. This isn't someone that they have to tiptoe around. They can go right after him. And isn't it important to continue with this narrative that R. Kelly was doing his thing? It was these others who were in charge of what was going on.
Absolutely expect they're going to go for the jugular. They have to. They don't really have a lot of choices otherwise. But remember, RICO is one of the easiest things for the government to prove. It's set up that way on purpose. If you've got more than one person, you're 2/3 of the way home in a RICO case. The biggest thing that R. Kelly's got is the fact of the matter that people will believe they know him and are familiar with him based on his notoriety. If you can use that to your advantage, that's the defense's strength. Other than that, for cross-examination today, like I said, aggressive to the point, no holds bar, take the gloves off and go at them.
Yesterday, Jane Doe 5 finished her testimony, very emotional and detailed. Then the government went the next step and they brought on a friend of Jane Doe to use some text messages that were exchanged in between 2015-16 that corroborated some of Jane Doe's basic testimony and the assertions. Some of them read as follows. This is from, this is basically what happened. As Jane Doe's messages subsided, the witnesses reached out several times, and it really painted this picture of somebody who became part of this and then changed. One of the texts said, this is supposedly coming from Jane Doe 5 to her friend, y'all can't do that because he checks my phone. Another one, he's gonna be like, why is that your best friend, BF, when you said you was texting your cousin? Another one, I just don't want to have to block your number. I have to show some age now that I'm with a 48-year-old man. I don't want to ruin the one shot I have of speaking to you. Rosalind, these are creepy. I mean, this furthers that narrative from the federal government that R. Kelly was keeping these women prisoners.
Absolutely. And because of the nature of the testimony of some of these young women, and particularly the one that you're talking about, the stories are outlandish, and bringing in some corroboration only substantiates the ghoulish nature of what was going on, because it is shocking. It's almost unbelievable that something like this could occur in modern day America, if you will. And it's almost unbelievable that individuals within R. Kelly's circle, and I'm talking about the individuals who comprise the enterprise, yes, the corroboration is something that is very, very compelling, and it will go a long way toward shaping the jurors' minds in this particular case.
And Doug Chanco, these are texts. These aren't. This isn't just testimony from a friend saying that this was said. This isn't hearsay. This is a text, and in the text says, "Now that I'm with a 48-year-old man, and I'm 17 pretending to be 18, that's going to turn a juror off, is it not? And it's going to, that to me is really damning here in terms of turning a juror towards the government's case and saying, ugh, here.
It certainly doesn't help. Again, it happens in every case when people have text messages, emails, or anything else in writing that they can't later kind of walk away from and say, no, my friend didn't understand, or they didn't hear it correctly, or they don't remember it correctly. It's in writing, it's there, it's plain as day, and it makes it really, really, really hard to backpedal on it. And that's what you're dealing with now, is it does bring out the ick factor of he's 48. You're not even close.
Yeah, and that continues this morning in New York. They should, again, start testimony at the bottom of the hour, 9:30 Eastern Time. Julia Janae there will update us throughout the day. Coming up, the judge presiding over the Jinx murder trial tells the state it's time to wrap up this cross-examination of Robert Durst. That's next. Stay with us. Welcome back. We're following what was a major development in the Jinx murder trial yesterday. The state's cross-examination of Robert Durst, we now know, could wrap up today. That's days earlier than expected. Prosecutor John Lewin said early this week that he planned to continue crossing Robert Durst well into next week. But yesterday, the judge said it's time to finish this up.
Under People versus Shazier, 60 Cal 4th 109 at 142, the prosecutor was entitled to explore reasons why information or opinion supplied by a defense witness might be less credible and reliable. For example, because of the witness's personal biases, evasiveness, or lack of familiarity with the relevant facts. That allowed broad cross-examination on over the objection of argument. The other case in Chapman, which I referred to previously, court should carefully scrutinize "they were lying" questions, that's in quotes. In context, they should not be permitted when argumentative or when designed to elicit testimony that is irrelevant or speculative. However, in its discretion, a court may permit such questions if the witness to whom they are addressed has personal knowledge that allows him to provide competent testimony that may legitimately assist the trier of fact in resolving credibility questions. And indeed, Mr. Durst has been confronted with things that he does know, and the questions go to his credibility. But sometimes there are objectionable questions and there is no objection posed. I do sustain objections to argumentative questions, so I don't think the defense can invoke futility here. So I know there's some frustration on the part of the defense that they don't seem to understand how I can allow these questions. The reason I'm allowing them is the authority that I've just described. So nevertheless, at times the questions become argumentative, and there is a bit of repetition there, though that's not a valid objection, but to the point of not using too much time. In many different areas, there is a slight misuse of time, Mr. Lewin, and you do take more time than you need to take, and that adds up so that cumulatively we have a problem, which I'm trying to address, and I will address, by limiting your cross-examination. So we'll see how you're doing at the end of the day tomorrow, and we'll see how much more is permissible. But you certainly may cover that subject matter that you described, but you can figure it out. You're a very good lawyer. You can figure out how to do it.
Let me propose something that might be of assistance to the court. The court is willing to let me have to the end of the day on Monday. I will not call the witness that I was going to have to call, the detective, to go back through to indicate all of the pieces of evidence that were in discovery that Mr. Durst is disputing. I will not call the Lenox Hill people regarding anything relating to the residency. I will basically take the court's observation that in essence, any person who's, and this is my paraphrase, not the court's, but that in essence, unless the jury is not paying attention, they cannot buy off on the residency issue, the match, etc. I won't call that witness. I will not call Detective Becerra, who I was going to call back to the stand. I will not call Bill Mayer, who I was going to call back on rebuttal. I will restrict my rebuttal to Andrew Jarecki and that one area. That cuts our rebuttal down from at least a day to about a half an hour. I'm going to ask the court if I agree to do that. The court already said we could have that day of rebuttal. I'm going to ask that the court, Your Honor, let me have, because I have to plan this out. I can't be in a position where I don't know what I get on Monday. So in exchange, Your Honor, that's a fair time exchange. I'm asking that I be given till the end of the day on Monday, and we will have our one rebuttal witness on Tuesday.
So I appreciate that, Mr. Lewin. So that is a very important consideration for me tomorrow at the end of the day when we see how you do, as well as whether the witness, for some reason, causes you to need additional time. But that's well taken. So, Mr. Chestnut.
I make a motion that you hit the bell.
Oh, before we do that.
And again, prosecution hoping now to wrap at the end of the day today. We'll see. Yesterday, Durst was pressed on something that John Lewin has been mentioning almost every day, his web of lies. Here's what Robert Durst had to say about that.
So instead of just saying, I talked to Kathy, you use a narrative where you say, correct, I talked to Kathy, it was about 10:30 or 11, she was watching the news. You include those details, Mr. Durst, because you found in your life of lying that when you include extra details like that, people tend to believe you more, right?
I do not have a life of lying. I have no idea what makes people believe one thing as opposed to another.
Well, Mr. Durst, what you did here is, instead of saying, I don't want to answer it, you said, I'm trying to remember what exactly I was doing in Garberville, and I've tried to remember, and I really don't know. That's what you said, correct?
Correct.
So your statement is right now that that was a lie. You were deliberately lying because you did remember. Is that correct?
I lied to you. That doesn't count.
Oh, wait, let me understand this. So lying to myself and police officers doesn't count. Can you please explain that?
Lying to you does not count.
Did you have your fingers crossed like under the table? So that's why it doesn't count? What does it mean it doesn't count?
It doesn't count. I was working on a plea bargain with you.
Didn't you originally say that you had lunch with your friend from college?
While I was at his house, we ate.
Well, you didn't mention that, though, right now when I just asked you. Did you forget that detail?
I didn't happen to mention it. I didn't tell you what else we did.
Well, I asked you to tell me everything you did, and you didn't mention lunch. Do you agree?
If I did not mention lunch, I did not mention lunch.
Have you found, Mr. Durst, that in the past you've admitted to lying and committing perjury, correct? You've admitted that, right?
Correct.
Would you agree, Mr. Durst, that you have found when you personally lie and commit perjury that you like to include a lot of details when you are committing your lies and perjury? Would you agree that's a fair assessment?
No, that is not a fair
argument.
Overruled. Would you agree, Mr. Durst, that just because...
Is it a new question, or am I answering the old question?
No, you just answered the other question. I'm answering asking another question. Would you agree, Mr. Durst?
I'm still on. Would you agree that I include a lot of details when I commit perjury?
I thought you said that's not true. Go ahead, you can answer that again, but I thought you answered it.
The 2 times I committed perjury, had to do with telling the court in Galveston that I was in Northern California when I was in Southern California, in terms of including lots of details. I don't include more details than I think are necessary to answer the question.
Still with us, former prosecutor and trial attorney Rosalind Charles. She's in West Orange, New Jersey, and criminal defense attorney and former prosecutor Doug Chanco is in Atlanta, Georgia. Rosalind, this case is a doozy, and it continues on. What are your thoughts on the judge saying yesterday, hey, we got to pick up the pace here, Mr. John Lewin? Was that the right thing for the judge to do, to step in and accelerate the process?
Well, the judge has to make an analysis, not just based on the rules of evidence, but also in terms of judicial economy. He also definitely has to balance the rights of the defendant in this particular case. However, if you're utilizing too much of the court's time in its opinion with testimony that ultimately can turn out to be cumulative, yes, I believe the judge did indeed make the right call in this case. He's got to wait and see, but he's kind of shot out a little warning like, this is taking a long time. I've heard all of this before, so let's kind of narrow the scope of our cross-examination. So he's going to wait and see until, I believe, tomorrow afternoon, and or at the end of today, excuse me, and hopefully all parties, specifically the attorney has gotten the hint that he needs to move on.
Doug Chanco, this is 18 months in the coming. Now you're going to, at the 11th hour, say hurry up? At this point, it's gone so slowly, I don't know what it's really going to do. Your thoughts on the speed of this entire process, but specifically the cross-examination of Robert Durst?
I got a huge problem with the judge saying, pick it up, I'm going to cut you off. Huge problem with that. Let the lawyers try their case. The danger that the prosecution has by taking too much time is the only person who wants to hear him talk is him. The jury doesn't want to hear it. He's the one who is making the decision to keep going because Durst says things that are absolutely damning to his own case. Because I'm saying it's mostly the truth, there are certain things I would lie about, certain very important things. This guy is a bomb, and the prosecutor's having fun with it. The point is, though, the jury understood that a long time ago. And let them keep going because the jury's going to hold it against the prosecution for wasting their time. That's the remedy. Not the judge sitting there saying, I want to step in and decide that you're done when I say you're done. That's creating a whole other list of problems to make this continue on and on and on. And if the judge was doing more than bluffing, which I hope is what it is, that could cause more problems for this case.
Yesterday, Robert Durst said, there's different types of perjury. There's major perjury and minor perjury. Take a listen.
Were you under oath, Mr. Durst, in a courtroom there?
I was under oath.
Do you agree you're under oath today?
I do.
Can you please explain to me, Mr. Durst, how either you were committing perjury during the Galveston trial when you said you were going to spend Christmas with Debbie, or you are committing perjury now when you are saying you were going to be spending Christmas on the staycation week with Susan?
Saying Christmas instead of New Year's, I think would be a very minor perjury.
There's minor, so now you got two minors. So there's perjury, there's minor perjury, then there's minor perjury. Is that your position?
Yes. The difference between saying Christmas and saying New Year's is very minor.
Rosalind Charles, are there different levels of perjury? Minor, and major?
Either you're credible or you're incredible. Either you lie or you tell the truth. And To my colleague's point, the prosecution is just having fun with him at this particular point. I kind of question, in fact, indeed, I question why this defendant even took the stand, because he has a history of lying, and the prosecutor's done a very good job of uncovering. In fact, most of this case is about his inability to tell the truth in the manner in which he weaves tales together. So, minor perjury, I guess they're white lies and innocent lies, and then there are major lies. He's an incredible witness, and he's not doing himself any good by taking the stand and giving the testimony that he's given. Absolutely.
Yeah. And he'll be back on the stand in a few hours in Los Angeles for more cross-examination. Will it be the last day? We'll have to wait and find out. Still ahead, we'll look at a case against the South Dakota Attorney General, who is accused of running over and killing a pedestrian last year and leaving the scene. He was supposed to go to trial starting today. I'll tell you what happened in that case next. Welcome back. We're following developments in South Dakota, where the Attorney General, Jason Ravnsborg, is expected to take a plea deal this morning to avoid a trial that was supposed to start today. Ravnsborg faced 3 misdemeanor charges for running over and killing a pedestrian on September 12th of last year. His lawyers says he will plead no contest. Court TV has obtained the interview that police conducted with the Attorney General just days after the deadly crash. The state's top prosecutor was driving home from a political fundraiser and claims that he thought he hit a deer that night, not a person.
I went through and I saw a sign that said 65 miles an hour, so I believe I started to accelerate. And then I saw a sign that said 48 miles to Pier. And you just kind of did one of those groans, like, oh, you still got 48 miles to go. And then, quite frankly, wham. Okay. I hit, the incident happened. I never saw anything until the impact. I immediately jump out of the car and call 911 within seconds. I believe my phone will show, and the records show 1024 is when I called.
You called 911?
Right. I mean, if I can demonstrate a little bit, I got out of the car and I jumped out, and I'm looking back towards Highmore, because I think I'm at Highmore, but now I'm shook up. Uh-huh. And I call and I said, I am the Attorney General. I am approximately a mile west of Highmore, I believe. I've hit something in the road. I need some assistance. Who is this? Is the response I get. And I think, and that's not 100%, but I think I said my name then, Jason Ravnsborg. I'm not sure. I remember thinking at the time, which was easier. It's not an easy name.
Right.
Mm-hmm. But I am walking back towards Highmore as I'm talking to her, because I'm trying to see that sign for the town to make sure that I'm at Highmore.
Okay.
And I think I said something like, yes, I'm at Highmore, a mile west of Highmore. And she said, the sheriff, something to the effect, the sheriff is the only one on duty and he'll be out soon. And I said, that'd be fine. I hang up the phone and I put it on the light, like it's got a flashlight feature, and I start to look at the highway, and I look at the road ditch to see if I can see anything that I hit, because I'm thinking it's a deer at this point, but I did not see anything. I didn't have a time to swerve or accelerate or decelerate or anything. I didn't see anything. And I then go to the front of my vehicle and I snap one picture of the vehicle, and I'm willing to give you that, obviously, too. And then the sheriff pulled up. So I stopped taking any other pictures, because he stopped, so it just interrupted me. And I said, and so that's Sheriff Volek, V-O-L-E-K, I believe is his name. And I said, he said, well, what happened? And I said, well, I believe I got hit by a deer, and it was in the middle of the road. I don't know. And he commented, and I shook. I mean, he looked at it. I mean, he's looking at my vehicle, and he said something to the effect of, well, at least it didn't knock out your side window, because it did not break the passenger window. And I'm looking at it, and I did not observe any blood or fur or anything. I did see, like I said, my debris was on the shoulder, and I believe I was on the road the whole time. He then said, well, get your registration and proof of insurance and come back to the car with me. So I get in my car, and I do that. I get those things, and I take those items back to the car, and he fills out, I guess I didn't bring that with me, I can show you that too, but he gave me a red tag, which basically means that you have, and it says on there, you've reported the accident to law enforcement immediately and complied with the law, basically. You got something similar, but I can obviously give you a copy of that. I'm willing to do so.
Okay.
He said, well, are you all right? And I said, yeah, well, I'm just shook up. I mean, I think I'm physically all right. I mean, but I'm shook up.
So, next morning, South Dakota Attorney General Jason Ravensborg found out that he did not hit a deer, but he killed a person, a pedestrian. Here's that part of the police interview.
So this is approximately 9:30 in the morning that we're at the site. I said, well, Tim, you go right from there was a chunk of my fender or quarter panel there right on the top on the shoulder.
Mm-hmm. On the north side?
On the north side,
okay.
On the shoulder, not down in the grass, up on the shoulder. And then you go left, or you go right and I'll go left. And I initially thought I saw it and it looked like a fawn or a deer in the ditch. So I said, I think I see something, but then I come up and it was the man. And he is not in good, I mean, he's dead. And so well, quite frankly, stammered, Tim, something to that effect, and trying to just get his attention to have him come up, and I kind of maybe run towards him a little bit, and Tim, you need to come see this. And I don't think I told him what I found. You need to come here and see it, and then he saw it. And I said to him next, well, we need to go find the sheriff again.
Still with us, former prosecutor, trial attorney Rosalind Charles, and criminal defense attorney and former prosecutor Doug Chanco. So, Doug, after some time and some investigation, the attorney general did face some 3 misdemeanor charges in this case after the investigation went through. Overall thoughts about this story that he's telling investigators? At this point, we're going to show you more right after the break, but it sounds somewhat legitimate, doesn't it?
Sure. It doesn't seem to be rehearsed. He doesn't have a lot of holes in it. And yeah, on the entirety of it, it makes logical sense. Hey, it's dark. I hit something. I don't know what it is. I tried to do the right thing. I called law enforcement. They showed up. I'm looking for fur and blood, and I don't know what it is. It adds up to anyone who's ever been driving at night and had something happen.
Now, on the other side, Rosalind, people are thinking, oh, he calls his buddy, or the sheriff comes up and they cover it all up, and this is a big cover-up. At this point, though, in the investigation and of the interview, your thoughts, it doesn't appear that there's a cover-up, does it?
At this particular point, no, it doesn't. And I pretty much agree with my colleague with the manner in which this was laid out. If you're driving on a dark road, I mean, you have no real obligation to look for pedestrians. Yes, you may have an obligation for your own personal safety to look for animals that are going along. But he hit something. He stopped. He investigated. He didn't run, if you will, or take off from the scene. And right now, everything seems to be working out okay. I mean, no fault situation.
Yeah.
But.
Oh. Yeah, but is a good one. And we're going to take a break. And coming up, we're going to get more from that police interview and what happens afterwards. One thing he didn't notice, he didn't see any fur or blood. He also didn't see the victim's glasses in his car. Stay with us. Welcome back. Coming up this morning at any moment, the attorneys for South Dakota Attorney General Jason Ravensborg are expected to enter into the record a plea deal in the case against their client. Ravensborg faces traffic charges from a crash last year when he hit and killed a man who was walking along a rural highway. Let's take a look at more of the interview that police conducted with the Attorney General. In this part, police get him to agree to let them search his vehicle, and then they press him on what they found and what he saw moments after the crash.
How much time did you spend looking for your insurance card?
The insurance card took a little longer. I mean, the other was right there. And then, because I remember I looked at it, and then it was not the right one. It's like the year behind.
Sure.
You know, and I looked at it, and that wasn't right. And I looked at it a little while longer, and I took it back to the sheriff. And then I said, I don't got the right one, you know. I mean, I think he was writing it out, and he says, hell, nobody's got the right one. Usually I got about 5 of them in the car. He said something to that effect.
Sure.
You know.
And that was on the visor, the other was in the glove box?
The glove box, yes.
Did you have to take things out of the glove box?
Yes, I had to move stuff around, yes.
Okay.
Yes.
Did you notice anything on the passenger side while you were doing that?
Just glass. I mean, I was staying away from the glass, I guess.
Okay.
I mean, I didn't spend a lot of time.
So when you're doing that, are you leaning over the console?
Yes,
or are you...
from the driver's door, leaning over, yes.
Okay. So you can kind of see in the glove box, and
right.
Which is already popped open.
It's already popped open, yes.
Okay.
Yes.
So, did you see the glasses right next to that?
I did not.
Okay.
You showed me the glasses the first time. The first time.
They're Joe's glasses.
I wondered about that.
So that means his face came through your windshield. It's a tough thing.
Oh. I was thinking that his face did not come through because there would have been blood. I thought there'd been blood everywhere then. Now, you know, after I've thought about it.
Yeah, and then you've had time.
Right.
His glasses are right there, Jason. Those are Joe's.
I did not see the glasses until you showed it to me.
Sure. So the only way for them to get there is through the windshield. At the impact, did you look over and see anything?
I did not see anything. I mean, it was, again, I then was looking to get it to the side. I did not see anything. No, absolutely not. You know, not. It shattered, and I probably cringed or something, but I was just trying to get it to the side. I did not see him. I did not know there was a human until the next day.
Okay, so
No.
when the glasses are in there, it's like his lenses, and we have a witness. We've talked to witnesses that actually had seen him out there as well.
I did not see those glasses.
One of the other things that we know, Jason, is you weren't in the middle of the road. You were on the shoulder. And I know it happens fast because it's happened to me. We have 3 people putting him next to the grass. So we knew something was happening. I mean, you're a smart man. You know, Joe and I have done this job a long time. We know what the evidence is going to show us, what the evidence does show us.
I don't remember. I remember being in the road, but you know, She'll show me what the evidence shows. But
Yeah. So part of the evidence that is really convincing is there is bone scrape on the inside of the rumble bars. And that's where his leg was likely broke. That's where the pieces were at.
So how did he get farther down the road? I mean, did he ride? How did that?
His face was in your windshield, Jason. Think about that. I got another question for you. Okay. Did you see the flashlight he was carrying?
No.
Ever? When you walked back to town?
No flashlight.
It was pitch dark out there.
Right.
And with it being pitch dark, we went out and tested it.
Okay.
We picked up the flashlight.
Right. Okay.
The flashlight was still on when Joe and I got to the scene.
Okay.
It had not been touched.
Uh-huh.
We picked it up and the light is still on.
Okay.
We talked to a witness that had just seen the light, had seen him walking with the light.
Okay.
After the crash, did you see that light in the dark? Because it's pitch dark. If there's something glowing,
right,
it would make sense for you to see it.
Right. I did not see any light, no.
Are you certain?
I am absolutely certain.
Okay, let's bring them back. Former prosecutor, trial attorney Rosalind Charles, a criminal defense attorney, former prosecutor Doug Chanco. This changes things a bit, Rosalind, and now we know why charges were filed. A plea deal, again, a plea deal was reached. This was going to go to trial starting today, but the defendant said, I think I'm going to go with the plea deal. The details of that have not been released yet. We'll find that out in a matter of moments. Your thoughts now, Rosalind?
Well, I think it's very compelling when the top cop thinks that he can outsmart the line officers who are doing the investigation. It's just absolutely amazing. He, quite frankly, would have made out better if he just explained what had happened, and as opposed to trying to hide the fact that he had indeed hit a human being. Because circling back to my original statements with regard to hitting pedestrians on a dark road, you have some leeway. I'm not suggesting that the killing was completely avoidable, but this particular prosecutor has lied on all fronts, not only about his positioning in the road, but the fact that he couldn't or didn't see. He was indeed traveling on the shoulder, and I'm surprised there wasn't any alcohol or anything that was found involved in this particular situation.
Well, he was tested.
He's in a lot of trouble.
Yeah, he was tested, but he wasn't tested for 18 hours after the incident. So by then, the alcohol, if there was any, he was coming from a fundraising event. He was a political fundraising event, and he was on his way home. Doug, your thoughts on what stands out to me is like, why the sheriff and he didn't see this flashlight? That's a moment. Your thoughts?
Come on, they saw the flashlight. This is just a guy with power trying to see what he can do to get out of a problem. But the most important thing to understand from this is it's yet another example of do not talk to the police. Do not give an interview. The only thing you need to do is say Fifth Amendment and stop talking, because you never can come up with the right lie. His story sounded great until, as Lee Corso would say, not so fast, my friend. And he got caught in the middle of it, and then he didn't know where to go. And that's why he starts shutting down at the end of the interview, because now he's trapped.
He's the top prosecutor. He should, as the investigator said, we've been doing this a long time. Rosalind, was it a good idea for him to come up with a plea deal here instead of going to a jury in this case?
Oh, absolutely. I don't necessarily know the ramifications of his plea, but I imagine that there will be no jail time involved. He may, quote unquote, get to keep his license. He certainly will likely, in fact, indeed, will lose his job and any of the benefits associated with it. So I think it's in the best interest for him.
Yeah.
And there are other implications for the victim and the victim's family.
Absolutely.
But-
And we should point out, we do have to take a break here. I want to say
Okay.
thanks to Doug Chanco. Rosalind's going to be back with us next hour. He did keep his job. Actually, he's still the Attorney General. Be right back. Top of the hour, welcome back. We have our eyes on courtrooms across the country this morning in New York, where day 7 of singer R. Kelly's federal sex abuse trial is underway at this hour. And then on the West Coast in Los Angeles County, Robert Durst facing another day, the 11th day on the stand. That's starting in just a few hours, and that is where we're going to begin, in California. Big moment in the trial happened at the end of the day yesterday. That is when the judge told prosecutor John Lewin he needs to limit his time for his cross-examination of Robert Durst. The judge wants this cross, wrapped up by today. That's the goal. Let's head out to legal correspondent Chanley Painter, who is in Los Angeles County with the latest on what we can expect today. Chanley, good morning.
Hey, good morning, Ted. Yes, today could be the final day of cross-examination for Robert Durst if Judge Mark Windham has his way. At the end of the day yesterday, the judge told the prosecutor he had until the end of today to complete his elongated cross-examination of Robert Durst, and the trial would be moving on. Now, Durst has been under cross-examination for 6 days so far, and the judge said it was becoming gratuitous.
Your cross-examination has been effective. It has been, I would say, devastating. But to use additional time at this point is, we're losing jurors. Jurors are sending notes. And not only that, there is at some point there's a toll even on the witness. I will consider that. Now you're right, I think, about aspects of his testimony. As I said, I don't believe it was credible in the first place. But it's at this point it's almost gratuitous. I think that you have a different conception of the case, I think, than anyone else.
Inside the courtroom on day 50 yesterday, tensions ran high between the attorneys and the judge as the defense lodged objection after objection on the ground of undue consumption of time. And for the first time yesterday, the judge seemed more inclined to grant that objection multiple times.
Mr. Durst, how come you did not make any effort to locate Danny and bring him to trial?
Objection 352.
What was the ground, Your Honor?
352.
All right. Mr. Durst, would you agree that if Danny were available, that he could help your case?
Objection 352.
Sustained.
All right, I'll move on.
Judge Windham is likely reading the room yesterday because I noticed inside the courtroom the jurors indicating their feelings about the tedious cross-examination and the multiple lies the prosecutor is exposing when they would raise their eyebrows, shift around in their seats, and some took occasional notes, still attentive, but it seemed weary even inside the courtroom on the jurors' faces. But also, Robert Durst also seemed frustrated with the prosecutor yesterday, at times yelling into the microphone.
Is it a new question, or am I answering the old question? I wish I could make facial expressions like you. Yes, that is my testimony.
Does it sound reasonable, Mr. Durst?
Very, very, very credible to me.
Today, we expect the prosecutor to wrap up his questioning along the line of Susan Berman's death and move to the Galveston timeline, Morris Black's death, as he indicated to the judge yesterday. It'll be another full day of cross, possibly the last one. So, Ted, be sure to tune in all day today. I'll send it back to you.
We will indeed, and we'll check in with you again, Chanley, in about an hour as we get ready for what could be the final day of cross-examination of Robert Durst. Let's bring back former prosecutor, trial attorney Rosalind Charles, and civil rights attorney James DeSimone is joining us from Los Angeles. James, good morning to you. Thank you for getting up early. To you first, James. This case, as we've talked about it before, it goes on and on and on. What are your thoughts of the judge saying, let's pick the pace up here, reading the room, as Chanley said, we got jurors, and by the way, started with 11 alternates, down to 5, lost one this week. Judge is getting a little frustrated. Your thoughts?
Well, still plenty of jurors, but it's about time, right? I mean, this cross-examination has gone on for days. I mean, he's been on the stand for 10 days, cross-examination 6. And the method of the cross-examination, while of course effective at times, because look at the material. I mean, Durst has lied about so much. It does get repetitive, and the type of questioning, I think, is less effective than prosecutor Lewin thinks he is. Who cares what Robert Durst thinks? This is not about what if he thinks that he committed perjury or not. This is about his pattern of lies in terms of covering up several murders. And if he would just focus on the big facts in this case, I think he'd win the jury. He doesn't need all this time. And finally, the judge is catching up and says, enough is enough.
Now, it does take two to tango, does it not? Robert Durst is part of this back and forth, and at times, Robert Durst, one could argue, is part of the problem in terms of the delays. Take a listen to an example.
I have no need to explain it. What I said is what happened.
So, Mr. Durst, when you say you have no need to explain it, do you understand that that's not a responsive answer? Do you understand that?
No, I don't understand that.
So you don't get to choose what you need to explain or not. Either my question is a legitimate question and the judge has overruled an objection.
You need
have
not
to answer
explain it. You'll answer the question, or there may be comment about your refusal to answer.
Can you explain it, Mr. Durst?
I don't see that there's anything to explain.
What I'm asking you to explain, Mr. Durst, is how it is that the phone worked on the 22nd, it worked on the 24th, and you're saying that while you were there on the 23rd, it did not work. That's what I'm asking you to explain.
352, objection.
Overruled.
When I picked up the phone, there was no dial tone.
Rosalind Charles, Robert Durst is playing this a little bit himself, is he not?
Oh, of course. I mean, what it does show is his arrogance in this regard, and it's not going to win him any favors with the jury. But I do agree that this is just getting tedious, if you will. It seems that we're going over and over minute areas of the same testimony. And what is on trial is the defendant, and what is important is his credibility. And I think throughout, the prosecutor should realize by this time that the jurors more than likely find him absolutely incredible. But his arrogance is not, the defendant's arrogance is not going to win him any favors. Neither is the evidence that has been produced throughout this entire, was it 18-month escapade?
Yeah, escapade, good term. Doug Chanco, James DeSimone, the problem, though, that could have arisen over this 18-month escapade, as Rosalind calls it, is that you could have a juror or two that is very comfortable with this individual who's accused of basically triple murder, and that could be a problem getting that individual to pull the trigger on a guilty verdict, could it not? The familiarity aspect of this, you know, it's having dinner with Grandpa, and he's telling the same story, and he makes a few mistakes. But that's expected, right? And the longer you're at dinner, the more forgiving you are for Grandpa's absent mind.
Well, that's true. I mean, you know, Durst, remarkable character in a way for a murderer, right? He has his likable aspects even in his feeble state. And so there is that danger. One big exchange yesterday was when he admitted, I don't know how many minors it was, but to committing minor perjury in a situation where it was simply a mistake. And perjury is knowingly telling a lie, which, of course, there's plenty of here. And, you know, with the cross-examination, he said, well, that's minor perjury because I got Christmas and New Year's mixed up. It wasn't perjury at all necessarily, although Durst has lied about the most critical things. I mean, in terms of finding Susan Berman's body, being in Los Angeles at that time, writing the cadaver note. I mean, all of these lies are big lies. And I just think that The prosecution would be better served honing in on that, focusing on that, instead of, as Rosalind said, these minute details that are going to get lost in the weeds after 12 days of testimony.
But that is a strategy from John Lewin, and he'll use it right in his closing arguments. You can hear it right now. And there was more of that yesterday, where Lewin is basically catching him in more of these lies. Whether they're major, minor, or whatever, they are lies because of those details. Take a listen.
So instead of just saying, I talked to Kathy, you use a narrative where you say, correct, I talked to Kathy, it was about 10:30 or 11, she was watching the news. You include those details, Mr. Durst, because you found in your life of lying that when you include extra details like that, people tend to believe you more, right?
I do not have a life of lying. I have no idea what makes people believe one thing as opposed to another.
Rosalind, is it too much getting into the weeds with each one of these discrepancies / lies where they lose effectiveness? To James' point, the big lies are the ones that you want the jurors to really concentrate on, especially during the deliberation process. The other stuff is really window dressing.
Oh, yes, it is. I would suggest that the prosecutor kind of, if you will, conclude his cross-examination, prepare his closing arguments, and utilize this, if you will, in the weeds of these very minute lies to bolster the very big lies that Durst has admitted to, or that the prosecutor has been able to reveal during the course of this trial. I can appreciate the lengthiness of this trial, I can appreciate the fact that it took place over the course of 18 months, and you may be overly concerned that maybe the jurors have forgotten certain things. But the jurors, I think, they've had the opportunity to take notes, and at the conclusion of the case, they also have the opportunity to have to do some readbacks on some of the testimony, if they choose to. But I imagine this jury has a pretty good sense of what they want to do.
Yeah, some of the jurors, according to Chanley Painter, who's in the courtroom, have filled up multiple notebooks. It's a long trial when jurors are like, wait, which notebook was that in? And they're paging through it. Still ahead, we'll look at some more testimony from the Jinx murder trial. Prosecutor Lewin zeroing in on a few bizarre coincidences in terms of the whereabouts of Robert Durst when his friend Susan Berman was murdered. That's after the break. Stay with us. Welcome back. Eccentric real estate heir Robert Durst is facing a 7th day of cross-examination in the Jinx murder trial. Durst is charged with the murder of his good friend Susan Berman. But the prosecution is trying to show the jury that her murder is also connected to the death of Morris Black and the disappearance of Durst's first wife, Kathy. Prosecutor John Lewin questioned Durst about how bizarre it is that he happens to be in the wrong place at the wrong time for all 3 incidents.
So again, would you agree, Mr. Durst, that both Susan Berman and Morris Black were existential threats to you?
No.
Would you agree that they both ended up dead in very bizarre incidents?
They both ended up dead.
Would you agree, Mr. Durst, that you're in the wrong place at the wrong time with respect to both of their deaths?
Absolutely.
And would you agree, Mr. Durst, that your wife going missing doesn't help your situation?
What is my situation?
What is your situation? Your situation is, Mr. Durst, you're a man whose wife disappeared, where you are the chief suspect, where Susan Berman is telling numerous people that you killed her and that she helped cover up by calling the dean, where Susan Berman told you she was going to talk to the police, where you have testified that you were aware that she told you that, where she ends up getting murdered with her brains blown out in her house, where you find the body, and then you also end up being in Galveston, living as a mute woman across the apartment from Morris Black, who's one of the only people in Galveston who knows who you are and can connect you up to that location. And he's allegedly going to end up pulling your own gun with you and being shot, and then you're going to admittedly dismember him and dump the body parts. That's the situation you're in.
Objection.
Is that a question?
Yes. He asked what's...
No. He asked you a question,
yes.
and you may not necessarily answer it.
That is the situation you are in, Mr. Durst. Would you agree that that is an untenable situation you're in?
Objection to the long narrative in front of the question, Your Honor. It's just not proper.
Overruled.
I think you have forgotten that Judge Whitman advised the jurors that the questions are not evidence, that only the answer is evidence. That whole long thing you went through is not supposed to be taken as evidence.
Mr. Durst, are you aware that the question is evidence when you figure in your answer to it? So a jury listens to the question, then they listen to your answer, and they evaluate both. Do you understand that?
No.
All right. I'm going to try one more time, Mr. Durst. Would you agree that whether or not you killed Kathy Durst, murdered Susan Berman, murdered Morris Black, that there are a lot of circumstances that are very difficult for you to explain?
It's irrelevant what he thinks, Dick.
Would you agree to that?
I'm not sure what you're asking me.
You're denying that you killed your wife, that you murdered Susan, and that you murdered Morris, correct?
Correct.
You're aware of all of the evidence that's been put on in this case, correct?
I don't know if I'm aware of all of it. I have a working knowledge of most of it.
And you're aware that I have been in my questions bringing up various issues in the case, correct?
You have been testifying in your questions.
Well, Mr. Durst, you've been answering those questions, and those answers to my questions are testimony. Do you understand that?
That's argument.
I know that my answers are testimony, are evidence. I am under the impression that the jurors are not supposed to view your questions as evidence.
The judge will instruct the jury, Mr. Durst. The judge has already explained that when you have a question, the question itself is not evidence. Your answers, which put the questions into perspective, and the answers which answer those questions are evidence. But here's my question. You're not answering me. Do you agree that whether you killed...
Lecture on the law, Your Honor.
Well, he's the lecture is actually the witness is invoking the the law that pertains to the case as an answer to the question, and the follow-up question is, it seems, intended to clarify the law for the witness. It's really not. It's a dialogue that's understandable, but also not useful. They're appropriate questions because they shed light on the witness and his attitude towards testimony, his credibility, etc. So I'm allowing the questions in this context, but I would like you to steer this back to the original question, and I didn't hear an answer to the original question. So if you'll go back to that rather than this side route.
And that's what I just asked again, Mr. Durst. Listen to my question. You would agree that whether or not you killed Kathy, whether or not you murdered Susan, whether or not you murdered Morris Black, that there is a lot of evidence in this case that is very difficult for you to account for?
That's the final argument. Argument. Object to the question.
No, overruled, but I was hoping you were getting more specifically to, in this situation, Mr. Lewin, in this specific situation, it presented a problem in the context of the other.
Right. Can you answer this question, or then I'll move to the specific?
Yes.
Can you answer my question, Mr. Durst?
I thought I was supposed to wait until the judge finished speaking, and I heard Judge Whitman say he'd like some specifics.
It's Judge Wyndham. It's not Judge Whitman.
Okay, thank you.
Sorry.
It's okay. You may you call me anything. Call me Your Honor, and you're safe.
All right, let's bring back former prosecutor, trial attorney Rosalind Charles, and civil rights attorney James D. Simone. Get the judge's name wrong, that's never going to be good. Rosalind, Judge Wyndham is an interesting part of another one of the characters in this courtroom, right? Because of the way he's ruled, the way he sort of fidgets around on the bench and gets energetic. At one point, when he's making his rulings, he adds little digs. In this last bit, he adds, it goes to the credibility of the defendant. He gets things there. Earlier, he said, I thought your cross-examination was devastating. That was outside the presence of the jury, but still, he has interjected himself maybe more than normal judges in normal courtrooms. Does that affect the proceedings, and how so?
Well, I don't necessarily, it definitely affects the proceedings. I was under the impression as I was viewing that testimony that maybe the defendant needed to be both judge in this case as well as his own attorney, because I was just waiting for Durst to say objection, basically. That's what I was waiting for, because that whole line of questioning with respect to the law, to me, really just went right up to the edge, if not crossed the line, because it is the judge who is the arbiter or who is supposed to be telling the jury what the law is. And typically that comes at the end of the case in full, but they're sitting here. Prosecutor and defendant are having, it's like a law school class. They are debating issues with respect to what his testimony may or may not mean. And in my opinion, that whole line of questioning was improper and should have been stricken from the record.
Yeah, and James, at one point, Robert Durst was instructing the jury that they should not take what the prosecutor says as testimony. Have you ever seen anything like this?
Not at all. I mean, again, this calls for a legal conclusion. Typically, witnesses are not going to testify as to how the jury will be instructed. In this instance, I think that, Durst on the one point is scoring some points and explaining the law, but on the other hand, he's very combative. I remember having a witness once. I was like, look, the jury, you want the jury to sympathize with you. If you're trying to prove that you're the smartest person in the room, the jury may actually hold that against you in certain circumstances because they think you should know better in terms of all your other evasive answers. So an interesting back and forth, but again, this shows the waste of time. I mean, in terms of him trying to get into what is in Robert Durst's mind in terms of evaluating the testimony, evaluating the evidence, instead of just putting on the evidence and making sure that the jury understands the evidence in order to convict Robert Durst.
Yeah, one of those moments of the back and forth, and one might argue waste of time, came yesterday when they were talking about that dig note, the DIG note, where it was just a list of words that was found in Robert Durst's trash can back when his wife was missing in 1982. And those two went at it again, did Lewin and Durst, and they were squabbling over, was it the word truck or was it the word trunk? Take a listen.
Isn't it true, Mr. Durst, that says trunk and not truck?
To me, it says truck.
So when you say to me, if I were to ask you, how certain are you that says truck and not trunk?
It says truck.
Okay, so your position is you are absolutely certain. Is that correct? Or not?
I am certain that word looks like truck.
Well, Mr. Durst, I'm not asking what the word looks like. You wrote that word, correct?
I wrote it.
Okay, so I'm asking you, not what does it look like. I'm asking you, first of all, you've said the word is truck. So I'm now asking you, how certain are you that the word is truck and not trunk?
I'm certain it's truck.
Would you agree, Mr. Durst, that if the word was trunk, that would be a very damaging, again, notation to have there? Do you agree that
Improper
trunk
hypothetical.
is far worse than truck?
Improper hypothetical.
Overruled.
I don't agree. I don't know how one is worse than the other.
Rosalind, was it truck or trunk? And does it matter?
You know, I forgot. It looked like trunk to me, but yeah, and the juror's going to have the opportunity to look at that evidence and reach his own conclusions with respect to it. So, yes, another situation where we're dealing with the minutia and wasting, in my opinion, the court's time.
But James, to Rosalind's point, the jury will get that in because it is made into a big deal and because there's a battle there. Now as a juror, I might be somewhat interested. I want to look at that note up close and get my readers on and determine for myself if I think that's a trunk or a truck.
Well, honestly, I think it's kind of impossible to see if that says truck or trunk. There's a C or an N missing there. So, but what about those other words? Dig, bridge, shovel. I mean, these are all things that you would do to make a body disappear. And we know that this is written at the time of Kathy Durst's disappearance, and her body has never been found. So there are some damning pieces of evidence on that piece of paper, whether that word is truck or trunk. I agree, trunk is worse, shows you might be putting somebody in a trunk, but in the end all and be all, it's the note itself that constitutes devastating evidence and not Durst's interpretation of what that word says.
Yeah, and both words, if you shovel, I think is worse than trunk or truck. Let's face it. Coming up, R. Kelly's federal sex trafficking trial underway in New York. Court TV's Julia Janae is there in Brooklyn. She'll join us from outside the federal courthouse right after this. Stay with us. Welcome back. It is day 7 in New York for the federal trial against R&B singer R. Kelly. The singer is facing a number of charges for allegedly running a criminal enterprise to lure and sexually abuse women and in some cases men. Attorneys arrived to the courthouse just about an hour ago where witness Tom Arnold resumed his testimony. He told jurors about his time working as an employee for the artist for several years at his studio in Chicago and then on the road as well. Court TV legal correspondent Julia Janae is outside the courthouse with the latest on this high-profile trial. Julia, what has happened so far this morning?
Ted, Tom Arnold is still on the stand. He is under direct examination, and he has given this jury a look at what R. Kelly's homes look like, his studios, actually seeing some exhibits that he is telling them about different rooms, different studios. It's unclear exactly what the prosecution is going to build from this because he's not giving much context as to why he's pointing out a basketball court, a dance room, a room that has a bathroom in it that also doubled as a studio. These types of things that he is explaining to them, he's really just identifying this. He worked for the defendant from 2003 to 2011, so he has a really up close and personal knowledge of how things worked inside his home, inside his studio, and he was someone who picked up female guests for the defendant often.
What about R. Kelly? Yesterday you told us that he was sort of avoiding eye contact with Jane Doe 5 and looking straight ahead. Different today? Is he looking at his old buddy, or is he doing the same thing from what you can tell?
He's looking more relaxed today. He's not doing as much writing this morning. Could be because of the content. This is really exhibit heavy right now when the prosecutor is asking the questions, but he does look more natural. It's not just looking in that one direction as he was when Jane Doe number 5 was on the stand.
Interesting. The first forensic witness took the stand in the case. Who was that, and what did the testimony ultimately show for the federal government?
This was Veronica Jackson. Now, we haven't really seen any kind of forensic or physical evidence being presented to this jury, but this was the first person to really talk about the science. And you see there, the prosecutor is holding a T-shirt. That is Jane Doe number 4's T-shirt that she says she used after being abused, choked, and thrown to the floor by the defendant after he also did a sexual act on her and then spit on her. She wiped her face up. And this forensic scientist was letting this jury know, or testifying about the substance on that T-shirt. She confirmed that there was semen on that T-shirt, but she said the tests for saliva were inconclusive. We know Jane Doe number 4, Joanna Pace, she gave that T-shirt to her lawyers after this encounter. That was the last day that she spent at the defendant's house. She said enough was enough, and she went and talked to lawyers about her 6-month experience there between 2009 and 2010.
The name Aaliyah mentioned again in court. Of course, Jane Doe number 1 died tragically in a plane accident. Why was she brought up again? What did jurors learn about her?
Prosecutors brought another witness to the stand, a Keith Williams, someone who knew the defendant Robert Kelly back in the 80s, early 90s, and he was someone who seemed to have some difficulty being there. Didn't seem like he wanted to be there. He even broke down crying a bit during his testimony that was relatively short and not very in-depth. The purpose of his testimony was to show that he got a pastor, or recommended a pastor for Kelly. He said Kelly came up to him in 1994 asking if he knew someone who could help him get married to Aaliyah. And because this witness was also working towards being a pastor, he knew a lot of pastors, he recommended a Nathan Edmonds, and that is who ultimately, it seems, as far as the testimony, was the officiant for that marriage back in '94 between Aaliyah and the defendant. Of course, she's named as Jane Doe number 1, but not for any kind of sexual abuse. It's a bribery charge that the defendant faces regarding Aaliyah, saying that he orchestrated the bribery of a state official to get her a fake ID because at 15 she would have been too young to get married.
But adds a lot of context to the overall world of R. Kelly, obviously, for the federal government as they present that bribery evidence. A lot of supporters outside the courthouse you've been reporting on say, free R. Kelly. We saw the murals yesterday, but now hearing from the other side, the hashtag Mute R. Kelly co-founder talking to Court TV. Any plans on them making an appearance?
I did ask that question of the co-founder, Kenyette Tisha Barnes. She spoke to us about this 2017 movement that they began to get the songs of R. Kelly pulled from the airwaves. They were successful in that movement, but we haven't seen their presence here at this New York trial. She said it wouldn't be safe to ask protesters or demonstrators to come outside in New York because of the pandemic, but she did talk to us about what it's like watching this trial unfold, the first for Kelly of many that are pending across the country.
Mute R. Kelly started in 2017 in Atlanta. And to be really clear, it started over coffee and mutual outrage. My co-founder and I, or Nike Odeleye, we both in our individual silos had just determined that enough was enough for R. Kelly. If you recall, in 2017, that's when that BuzzFeed article came out detailing horrific details of what was happening in a house in Johns Creek, in Fulton County, in the Atlanta area. And around that time in the summer, R. Kelly was supposed to perform in a taxpayer-funded arena in the same county in Georgia. And at that point, enough was enough. So my co-founder and I and our two silos got together and we came up with this idea that why don't we bring together the backgrounds of activism and lobbying and call for a financial boycott, and also call for people to come and put their bodies in the street and say enough is enough and to mute R. Kelly.
Ted, we got a little bit of insight this morning from the judge and the parties outside the presence of the jury on who is going to be coming up next. There's a John Doe #1 who they say is on the list to testify today, and they were trying to figure out the scheduling on whether or not he would be able to testify with Tom Arnold perhaps going long. The defense said they have another motion in limine they want to file. This is someone who knew the defendant back in the 90s, was allegedly groomed by him, and had sexual relations with people at his behest, but also someone who actually is accused of tainting the jury in some way back in the 2008 trial.
Interesting. All right. That, again, today, we're possibly, depending on Mr. Arnold's testimony. Julia Janae, thank you. Julia will be reporting throughout the day from New York on this ongoing trial. Let's bring the guests back in. Former prosecutor, trial attorney Rosalind Charles. She is in the New York area, in West Orange, New Jersey, and civil rights attorney James DeSimone in Los Angeles. Rosalind, you're there in the Northeast there. This trial, it's in federal court, so we don't get to see it play out, real time like we are the Robert Durst trial, because no cameras are allowed in federal court. But Julia is bringing the courtroom alive for us, and this individual on the stand now, he was part of this operation. What are you expecting from the defense in terms of cross and the length of it, and a possible opportunity here to deflect some of the blame, if you will, or responsibility, leadership away from R. Kelly onto others in the organization? Is this one of the witnesses you can do that with?
I believe that it is. I don't necessarily know how effective it's going to be, but this particular individual has its own issues in, if you will, in criminality as being. But I would suggest that the prosecution is going to have a great time, an easy time, if you will, making him look like part of this overall criminal enterprise. But individually, I believe that he has some issues himself. And yes, you could kind of put the blame on him, but only for this particular incident for which he is going to be testifying about. And with the overall evidence that is being presented, if successful in demeaning his credibility, it'll just be a small, or what do they call it, a Pyrrhic victory in the context of the overall damning evidence that is being presented thus far.
Might win a small battle, but lose the war at the end of the day. James, this is post Harvey Weinstein. So yes, you've got people outside the courthouse, free R. Kelly. It feels a little bit at the courthouse like Santa Maria, California, with Michael Jackson, who was found not guilty back in the day. There was a pressure in California, one would argue, to really look at this case because Michael Jackson is beloved. There's a component there of that with this R. Kelly case, but this is post-Harvey Weinstein, also a New York case. Which of the two camps is going to filter into this jury, or neither one? Do you think this will be an insulated case that will be, the outside forces won't matter?
Well, I think Michael Jackson was much more beloved and had much more support here in California than R. Kelly has in New York, from my looking at some of the prior film of what's going on outside that New York courthouse. I mean, R. Kelly is just not Michael Jackson, and there are fewer victims with Michael Jackson than we have with R. Kelly. And so when you look at the type of degradation and the humiliation, just the dehumanization of these women, the way they testified they were treated. There is no sympathy in that situation for R. Kelly. There's no excuse for treating another human being the way in which R. Kelly is alleged to have treated these women. And when you have the variety of the number, rather, of women who are testifying about it, as well as people who are employed by him, the evidence seems to be overwhelming. And what was beautiful in your last segment, I thought, to take a tragedy and just a heinous crime, is the effect of social activism. I mean, here are two women who are connected, but having coffee and say, you know what, we're going to make a difference. And they did make a difference. R. Kelly's music was taken off the air. The people that he did music with, they said, hey, we did a duet with him. We don't want him on the air anymore. And I think that ultimately who's going to be on that jury is going to listen to the evidence in trial, as they always swear they're going to do. And the evidence here is going to result in guilt.
Absolutely effective. We're going to step aside, take a break. When we come back, we'll talk about the Michigan governor and the plans to kill her. One of the individuals learns his fate. That's next. Welcome back. A man who played a significant role in the kidnapping plot of Michigan Governor Gretchen Whitmer has learned his fate. A judge has just sentenced Ty Garbin, or he sentenced him yesterday, to 6 years in federal prison. He pled guilty earlier this year to kidnapping, a kidnapping conspiracy charge. He's one of 6 defendants in the case, and he's cooperating with federal prosecutors against his co-defendants. A prosecutor says Garbin is expected to be the star witness when he testifies against the others at trial. At the sentencing yesterday, Garbin briefly apologized to Governor Whitmer and her family. Here's reaction from his attorneys.
So yes, Ty absolutely came to us and said, this is what I'm going to do. And we said, well, we haven't even gotten discovered. We haven't even told you whether we can win or not. I don't care. I know what I did, and what I did was wrong.
But he also tried to make amends for what he did by cooperating and then, being smart enough to know that, all right, I need to do more to better myself after this by de-radicalizing and then helping others.
This was a case that just sent shockwaves across the country when it was first reported. Here's Michael Martin from our affiliate, WXMI in Michigan, taking a look at the details of this case.
Bye. The story of these 5 men, all facing charges for allegedly plotting to kidnap and kill Michigan Governor Gretchen Whitmer, has reached every corner of the world. The government says the plot was dead serious, amassing a trove of undercover audio and video recordings through the use of 12 informants that they say will prove the group intended to carry out their plans.
So I would expect that there's a lot of evidence. How strong that evidence is to show that they actually were going to go forward with the plan, that's something else.
One of the defendants, Ty Garbin, has agreed to cooperate with and testify on behalf of the government. The prosecution says he confirmed to them that the plot was, quote, real, not just big talk between crackpots.
Unfortunately, in federal prosecutions involving conspiracies of any kind, drug cases, conspiracies like this, one thing that does happen is that certain people are essentially offered cooperation deals, and that can sometimes strongly support the government's case.
Garbin's defense team submitted 16 letters of support to the court from family, friends, and a short report from Parents for Peace, a group that works to disengage people from radical ideologies. It reads, quote, him joining this group was his psyche attempting to make sense of the overwhelming emotions happening inside of him and helplessness he felt from the pandemic. We liken this to substance abuse, where the ideology becomes the drug of choice.
Now the government has somebody who was on the inside, who was not working for the government prior to charges, saying that in fact what the government claims to be true is true. The other side of that coin is that person saying it in exchange for extraordinary consideration and possible sentencing down the road.
Prosecutors asked the court this week to grant Garbin a 4-level downward departure from the typical sentencing guidelines, saying by agreeing to testify, he, quote, willingly put a target on his back to begin his own redemption.
And one way that the defense would show that is, they gave this guy a great deal because they really don't have a case otherwise.
Attorneys for the other 4 men charged federally are now laying the groundwork for an entrapment defense, saying they never would have sought to actually kidnap the governor if it weren't for some of the undercover informants goading them on.
It's a very tough mountain to climb. You essentially have to show that the government was acting in an outrageous way by having somebody commit a crime that they otherwise would not have committed. So if the defendant or the person charged in any way was predisposed to commit the crime, or there's evidence of that, it makes it more difficult to prove an entrapment defense.
Defense attorneys for the men continue to request more evidence from the prosecution, but the feds claim that Garbin's statements contradict any notion of entrapment, writing that he, quote, dispelled any suggestion that the conspirators were entrapped by government informants.
I think it's important for people to not judge whether or not someone is guilty and let the court system do that. You don't know what the facts of the case are. There's so many more pieces of discovery that the public just doesn't know. Let the system play out.
Coming up, we are live in Los Angeles County. Chanley Painter is going to join us as the Jinx murder trial is about to begin for the day in just about an hour. The judge telling the state time to wrap it up. We'll check in with Chanley right after this. Stay with us. This is Court TV, your front row seat to justice. Top of the hour, welcome back to Court TV Live. I'm Ted Rollins. Glad to have you along with us on this Thursday. We have our eyes on courtrooms across the country this morning. In New York, where day 7 of singer R. Kelly's federal sex abuse trial has been underway for about an hour and a half. And then on the West Coast in Los Angeles County, Robert Durst facing his 11th day, could it be the last, on the stand. That begins next hour. Robert Durst has been on the 6-day cross-examination marathon via prosecutor John Lewin. He has Lewin methodically brought up many of Durst's inconsistent statements in an effort to connect him to the death of his longtime friend Susan Berman. As the day came to a close yesterday, the judge said that Lewin's cross has been excessive, and he told him to wrap it up.
Sometimes there are objectionable questions and there is no objection posed. I do sustain objections to argumentative questions, so I don't think the defense can invoke futility here. So I know there's some frustration on the part of the defense that they don't seem to understand how I can allow these questions. The reason I'm allowing them is the authority that I've just described. So nevertheless, at times the questions become argumentative, and there is a bit of repetition there, though that's not a valid objection, but to the point of not using too much time. In many different areas, there is a slight misuse of time, Mr. Lewin, and you do take more time than you need to take, and that adds up, so that cumulatively we have a problem, which I'm trying to address, and I will address, by limiting your cross-examination. So we'll see how you're doing at the end of the day tomorrow, and we'll see how much more is permissible. But you certainly may cover that subject matter that you described, but you can figure it out. You're a very good lawyer. You can figure out how to do it.
Let me propose something that might be of assistance to the court. The court is willing to let me have to the end of the day on Monday. I will not call the witness that I was going to have to call, the detective, to go back through to indicate all of the pieces of evidence that are in discovery that Mr. Durst is disputing. I will not call the Lenox Hill people regarding anything relating to the residency. I will basically take the court's observation that in essence any person who's, and this is my paraphrase, not the court's, but that in essence, unless the jury is not paying attention, they cannot buy off on the residency issue, the match, etc. I won't call that witness. I will not call Detective Becerra, who I was going to call back to the stand. I will not call Bill Mayer, who I was going to call back on rebuttal. I will restrict my rebuttal to Andrew Jarecki and that one area. That cuts our rebuttal down from at least a day to about a half an hour. I'm going to ask the court if I agree to do that. The court already said we could have that day of rebuttal. I'm going to ask that the court, Your Honor, let me have, because I have to plan this out. I can't be in a position where I don't know what I get on Monday. So in exchange, Your Honor, that's a fair time exchange. I'm asking that I be given till the end of the day on Monday, and we will have our one rebuttal witness on Tuesday.
So I appreciate that, Mr. Lewin. So that is a very important consideration for me tomorrow at the end of the day when we see how you do, as well as whether the witness, for some reason, causes you to need additional time. But that's well taken. So, Mr. Chestnut.
I make a motion that you hit the bell.
Oh.
Let's head out to Court TV legal correspondent Shanley Painter, who is live in Los Angeles County covering the trial for us. Good morning to you, Shanley. This is the big question. Is today the last day of the cross-examination of Robert Durst? Because John Lewin this week said, I need at least until midweek next week. I guess it's wait and see after what the judge said at the end of the day.
It really is. It's going to be a wait and see how much progress the prosecutor makes in one day today. The judge wants him to be done today and move on with this trial. Yesterday, I again noticed the 200-page outline in Prosecutor Lewin's hands. He's not even halfway through it compared to what page he was flipping on. So he has a lot more to go. That's why he was so adamant in really trying to get the judge to let him go till Monday, early next week, to continue this cross-examination, even asking or suggesting that he wouldn't call some other rebuttal witnesses to save time overall in the trial. So we'll have to wait and see. It could be the final day of Robert Durst on cross-examination today if the judge does have his way. And we are expecting questions to really revolve around more about Susan Berman, her life, her growing up, her situation at the time of her death, and possibly even moving into the Galveston testimony of Robert Durst. The prosecutor yesterday told the judge he was really keen to get in those talking points before he finished his cross-examination. And if we want to look at a comparison of how long Robert Durst has been on the stand and how far he still maybe has to go, we compared it to the trial infamous defendant Jodi Arias. She was on the witness stand for 19 days. Robert Durst, 12 days so far, Ted. And the Jodi Arias trial, it lasted around 5 months, and she, of course, was convicted. But Robert Durst, his trial, 3 months in comparison to that. So another infamous defendant here in California. And really, Robert Durst doesn't seem to be weary. He was a little bit frustrated yesterday at times, but given his overall condition, Ted, inside the courtroom, he's really holding up well.
Yeah, absolutely. If you think back when his attorneys argued that he might die if he was exposed to taking the stand in his own defense, different story. I sat through that Jodi Arias trial, and she was a doozy. Her and Juan Martinez went at it a lot like we're saying today, where it's not just a day at the office for the prosecutor. Both prosecutors very invested, and we're seeing that with John Lewin. And even if they do finish up cross, obviously, Shanley, he's still on the stand because there'll be redirect, recross, etc. All right, so Lewin yesterday gets into the timeline a lot, where he really seems to be honing in on Susan Berman's death and Robert Durst's timeline surrounding it.
He does. He spent a bulk of the cross yesterday afternoon trying to pin down the exact timing from Robert Durst's direct testimony with his attorney, Dick DeGuerin. And he was comparing it much to the medical expert testimony about the condition of Susan Berman's body. So essentially, Robert Durst contends that he called Susan Berman the night before he arrived at her house around 11 p.m. and around 10 a.m. the next day is when he said that he found her body. But there was some back and forth as far as if that was really reasonable or possible. Let's listen.
Her breath was cold, correct?
Well, that's clearly not right. She wasn't breathing.
But that's what you said, correct?
No.
Sure.
Jack, that's not what the record reflects.
Oh, I think it does. Overruled.
And Mr. Durst, then you said that actually it was her face that was cold, correct?
It was her face that was cold.
And Mr. Durst, are you alleging that based on your examination or your contact with Susan Berman, that her face was a different temperature than the rest of her body?
I am not alleging anything like that. All I'm saying is I put my hand over her nose and mouth and it felt cold.
Can you explain, Mr. Durst, why her face would have been cold if she was just killed?
How would I explain something like that?
Yes, that's the question, Mr. Durst. How would you explain that?
I would ask Doctor whatever his name is to explain it.
So the prosecutor goes on to talk about rigor mortis and what the expert testimony was, and if that timeline made sense, well, it wouldn't make sense is what the point was, Ted, because she would have been alive at 11 p.m. the night before if there was time for full rigor mortis to set in, which is post-mortem rigidity, fully develops at 12 hours, but there's this really extended amount of time of 18 to 36 hours, and based on Robert Durst's description of her body at the time he found her, it really wouldn't have added up in the timeline if it was in fact true.
Yeah, and it seems we'd all predicted that, Durst is going to get under Lewin's skin, but might be the other way around here that we're witnessing, where Lewin is getting under Robert Durst's skin a bit.
I noticed more so yesterday. You are correct, because at times, I think the whole feel in the room was a bit frustrated at times, even on the jurors' expressions when they were listening to some of the testimony, when Lewin would ask a question and Robert Durst would try to deflect an answer, and it was like the jurors would shift around in their seats a bit or raise their eyebrows because they know that here comes another long line of questioning trying to pin Robert Durst down, and even Robert Durst seemed a bit annoyed. Let's listen to part of that.
You picked up Diane at the hospital? You picked her up at the hospital?
Yeah.
What time was that?
Around 4.
Well, when you say around 4, you're making calls from Garberville about 3 o'clock, so it's an hour, you said. So you would agree you couldn't have picked her up before 4 o'clock, correct?
Well, I think I've said it's 45 minutes to an hour. The road that takes you from Eureka to Garbersville goes right through the redwood forest. It's very difficult to time things because frequently you would get behind a big truck with lots of logs on them and you'd go 30 miles an hour for a long period of time.
And you can get stuck behind a truck with a lot of logs. Had the logs ever come up where you've had to bow saw them? I'll withdraw the question.
I'll answer the question.
No, I'll withdraw it. So, Mr. Durst, what time approximately did you pick up Diane Boucher from the hospital?
I just did that approximately 4 o'clock.
There were even times said in the courtroom that Durst seemed to be almost yelling into the microphone. At one time, he imitated Prosecutor Lewin, saying, "I wish I could make those facial expressions," and then tried to. It was very odd and very tense. You can tell that Lewin is getting under Robert Durst's skin, and Lewin sometimes seems a bit frustrated in what Robert Durst is doing as well.
Yeah, do these jokes go over with the jury that you've noticed? I mean, sometimes we'll hear some laughter. But you know, that last one, did you use a bow saw? Did you ever have to use your bow saw with these logs? Obviously, a reference to cutting up Morris Black with a bow saw. That seemed like a lead balloon moment. What is the engagement level with the jury in this back and forth?
It depends on the comment. Some get more of a response from the jury than others. That one, I remember being in the courtroom yesterday for that one, and it was more of a response from the gallery, us kind of giggling back there than the jury. The jury kind of went past them. They seem a bit used to it. This is day 51 of the trial, and so they're used to the antics between the attorneys and the judge, and then Robert Durst's been on the stand for so many days now. But you will see a couple of them, again, kind of raise their eyebrows or roll their eyes or they have masks on. It seems as though they're smiling in these moments, but you can't tell for sure.
Yeah. All right. Chanley Painter will be in the courtroom again today. And could this be the last day of cross-examination? Won't be the last day that Robert Durst is on the stand. Still ahead, Robert Durst brings up a new name and a new reason for being in California days before Susan Berman was murdered. We just heard that earlier. We'll look at more of this testimony from the Jinx murder trial next. Stay with us. Welcome back. About 45 minutes from now, court will resume in Los Angeles County in the Jinx murder trial. Let's look back at a moment from testimony earlier this week. The defendant, Robert Durst, brought up a name of someone that we hadn't heard before he brought it up, Diane Boucher. Durst now says he went to San Francisco days before Susan Berman's murder to help his friend Diane. Here's a look at some of that testimony.
What I'm asking you, Mr. Durst, is would you agree that you needed and you need currently to be able to explain why you had to stop in Northern California first, and that Diane Boucher is a very convenient reason? Would you agree? Even if it's true, it's convenient.
It's true, and I don't understand what you mean by convenient.
What I mean by convenient, Mr. Durst, is that you're in a position where you need to explain why it is that you ended up going to Northern California only to get in a vehicle shortly thereafter and drive all the way down to Southern California. And that saying you have to take care of Diane Boucher is a convenient way of explaining, hey, here's why I had to go to Northern California first. Would you agree that what I'm saying is correct, even if the excuse is true?
Object. Argument.
Overruled.
I had to go to Northern California, and I had to go to Southern California. I could either fly to Los Angeles. No, it made total sense to do what I did because Susan and I wanted to drive up to San Francisco and stop in Big Sur on the way. I could have flown to Los Angeles, but then there'd be no way to get to Big Sur.
Well, Mr. Durst, couldn't you have rented a car? Couldn't you have flown down to Los Angeles and rented a car?
I could have flown to Los Angeles and rented a car and driven it to San Francisco, but I'd rather do it in my car.
You would agree, Mr. Durst, that that is an absolutely horrific 15 to 16-hour drive from...
It's more like 12 or 13 hours.
Would you agree, Mr. Durst, that in the route that you're taking down there, you're not going down Highway 1. It's an ugly drive that's not very enjoyable. Would you agree?
It's a terrible drive.
And you're a multimillionaire, and you're saying you just chose to take that drive rather than fly down and rent something. Is that correct?
Somehow, Susan and I came up with plans that I would join her for a staycation in Los Angeles for 4 days. And then we would drive to San Francisco, stopping in Big Sur. And she was going to have friends of hers meet us at a restaurant called Nepenthe. And then we were going to drive to San Francisco the next day and meet with the architect, Mike Yoshida, at the townhouse that I had bought, that I had offered Susan the ground floor of.
So the question, though, that I'm asking you, Mr. Durst, is you could have done everything you just said except flown down to Los Angeles, saved yourself the horrible drive, and then done everything else you just said, correct?
What would I do with my SUV?
What would you do with your SUV? Well, Mr. Durst, you could have waited to pick it up until you got back. You could have kept it parked where it was parked. You could have parked it at an airport. Do you think all of those options would have worked?
Object to the form of the question, Your Honor.
Overruled.
He made it a question.
You could have done any of those three things I just said, correct?
I thought what Susan and I had planned on, well, actually Diane and Susan and I had planned on, sounded like a very pleasant way to spend 2 weeks.
Wait, Diane was going to come down with you as well?
No, but Diane made friends with Susan Berman when Susan Berman visited me in Trinidad.
But what does Diane have to do with the planning? I thought she's having female surgery.
That's what I was doing with Diane.
Mr. Durst, can you explain why during the March 15, 2015 interview that you had with me that you never mentioned anything about Diane Boucher?
I don't think I was asked anything about Diane Boucher.
Mr. Durst, you were repeatedly asked about your trip to California and your trip, as I accused you of going to Los Angeles, correct?
Correct.
So, Mr. Durst, when I was repeatedly asking you what you were doing in Northern California, do you recall that?
I don't recall that.
Do you recall me saying to you, Mr. Durst, you don't usually take 4-day trips, Bob? And you responding, yes, that's correct. I don't usually do that. Do you recall that?
I did not intend to take a 4-day trip.
And Mr. Durst, at any point in time when I was asking you about that trip, you could have certainly said to me, hey, John, I was going there to help Diane Boucher with her female problems, correct?
I could have said that, yes.
And you told me that you were trying to get a plea bargain with me by telling me as much information as possible. So can you explain why you didn't produce that information?
I still have a lot of difficulty.
What's that?
Relevance.
You're good.
Can you explain why you did not mention that information?
I cannot, but I also did not tell you that I got the car washed.
James DeSimone is still with us, civil rights attorney in Los Angeles, California. Little objection there from Robert Durst, relevance, and then a joke. I didn't tell you about getting my car washed. That's why I didn't tell you. Yes, all right. He didn't mention Diane Boucher earlier when he talked to Lewin, but Lewin takes it to a level where he really does want to be correct on everything and wants everybody to agree with him that he's right, Durst is wrong. And there are so many of these things that ultimately he's not going to win that, right? At the end of the day, it's not going to be $1 million for Lewin, 0 for Durst. What he really needs is more 70-30, and he's going to get a conviction here. Your thoughts on getting so deep into these lies that, let's face it, took place 21 years ago, all this.
Well, if he's going to get done today, and the judge has really told him, get done today, I may or may not give you time on Monday, I think he should take 2 words out of his examination questions. One is explain, and the other is why. Because the fact is that he left out when he was questioned by Lewin back in New Orleans when he was arrested that he ever took his friend to the hospital. Just establish that fact. I think where Lewin makes a mistake is allowing Durst to explain why he would do certain things and to get inside, once again, into Durst's head in terms of what he was thinking. Just let the lies stand on their own. You did not ever mention Diane Boucher before. You testified in trial today. Is that correct? Yes. End of story. Go on to the next topic. Let the lie sit there for the jury without giving Durst an opportunity to explain.
Yeah, it's a great point because now he goes back and he just has those that he can bring up in the close. They're clean, right? Did this happen, and this happened. And the three of them, that's a big thing. And actually, the list is much longer than that. But you're right, because now when he brings them up, the jury's got to evaluate the validity of each one of them because they remember Durst's long-winded explanation and the minutia that went along with it. It adds this complexity, and then you add the length, you add the familiarity, and doesn't it help Robert Durst at the end of the day?
Does, because I mean, you know, I'm thinking about the drive to Big Sur, which is okay. It's a long, winding road. I've done it several times in my life, but it's a beautiful drive. It's around Christmas time, you know. She's dead on December 23rd. So why is this such a horrific way to travel if you want to stop and smell the roses and see the sights? The real bad drive, although it's only a 5-hour drive, is up 5, where, you know, you just basically see nothing on either side of the road. So again, why go into the details in terms of what's in Durst's mind, and just go to the point of you went to San Francisco, you drove to Los Angeles, and as soon as you drove to Los Angeles, the first thing that you encountered was a dead body. And just go through those facts in terms of, I mean, I would be emphasizing so hard what he did in terms of when he found Susan Berman's body, and here you have a friend who you see is dead and basically abandoning her there with a note to the Beverly Hills police. Come on, who does that?
Yeah, you're right. And you're also right about the I-5. I mean, Harris Ranch, maybe it's a nice stopover, but whew, that's a tough drive going, which he did do, actually. He stopped at Bakersfield.
I'm doing it tomorrow. I'm going to Napa. But, you know, now we have a good reason. I'd rather drive than fly. I don't want to get on an airplane. It's so there's a different dynamic with COVID in terms of those choices.
Absolutely. Still ahead, we'll take a look at the case in South Dakota where the Attorney General is accused of running over and killing a pedestrian last year and leaving. He was supposed to start trial starting today, but he's not. We'll tell you what happened after this. Stay with us. Welcome back. We are following developments in South Dakota. The Attorney General, Jason Ravensborg, is expected to take a plea deal this morning to avoid a trial that was supposed to start later today. Ravensborg faced 3 misdemeanor charges for running over and killing a pedestrian on September 12th of last year. His lawyer says he will plead no contest. Court TV has obtained the interview that police conducted with Ravensborg days after the deadly crash. The state's top prosecutor was driving home from a political fundraiser and claims that he thought he hit a deer that night, not a person.
Through, and I saw a sign that said 65 miles an hour, so I believe I started to accelerate. And then I saw a sign that said 48 miles to Pier. And, you know, you just kind of did one of those groans, like, oh, you still got 48 miles to go. And then, quite frankly, wham. Okay. I hit, the incident happened. I never saw anything until the impact. I immediately jump out of the car and call 911 within seconds. I believe my phone will show enough records. 1024 is when I called.
Called 911?
Right. I mean, if I can demonstrate a little bit, I got out of the car and I jumped out, and I'm looking back towards Highmore because I think I'm at Highmore, but now I'm shook up. Uh-huh. And I call and I said, I am the Attorney General. I am approximately a mile west of Highmore, I believe. I've hit something in the road. I need some assistance. Who is this? Is the response I get. And I think, and that's not 100%, but I think I said my name then, Jason Ravensborg. I'm not sure. I remember thinking at the time which was easier. It's not an easy name.
Right.
Mm-hmm. But I am walking back towards Highmore as I'm talking to her because I'm trying to see that sign for the town to make sure that I'm at Highmore.
Okay.
And I think I said something like, yes, I'm at Highmore, a mile west of Highmore. And she said, the sheriff, something to the effect, the sheriff is the only one on duty and he'll be out soon. And I said, that'd be fine. I hang up the phone and I put it on the light, like it's got a flashlight feature, and I start to look at the highway, and I look at the road ditch to see if I can see anything that I hit, because I'm thinking it's a deer at this point, but I did not see anything. You know, I didn't have a time to swerve or accelerate or decelerate or anything. I didn't see anything. And I then go to the front of my vehicle and I snap one picture of the vehicle, and I'm willing to give you that obviously too. And then the sheriff pulled up, so I stopped taking any other pictures because he stopped, so it just interrupted me. And I said, and so that's Sheriff Volek, V-O-L-E-K, I believe is his name. And I said, he said, well, what happened? And I said, well, I believe I got hit by a deer and it was in the middle of the road. I don't know. And he commented, and he looked at it, and he's looking at my vehicle, and he said something to the effect of, well, at least it didn't knock out your side window, because it did not break the passenger window. And I'm looking at it, and I did not observe any blood or fur or anything. I did see, like I said, my debris was on the shoulder, and I believe I was on the road the whole time. He then said, well, get your registration and proof of insurance and come back to the car with me. So I get in my car and I do that. I get those things and I take those items back to the car, and he fills out, I guess I didn't bring that with me, I can show you that too, but he gave me a red tag, which basically means that you have, and it says on there, you've reported the accident to law enforcement immediately and complied with the law, basically. You got something similar, but I can obviously give you a copy of that. I'm willing to do so. Okay. He said, well, are you all right? And I said, yeah, well, I'm just shook up. I mean, I think I'm physically all right, but I'm shook up.
So it wasn't until the next morning that the South Dakota Attorney General, Jason Ravnsborg, found out that he did not hit a deer, he hit a human being. Here's that part of the police interview.
So this is approximately 9:30 in the morning that we're at the site. I said, well, Tim, you go right from there was a chunk of my fender or quarter panel there right on the top, on the shoulder.
Mm-hmm. On the north side?
On the north side,
okay.
On the shoulder, not down in the grass, up on the shoulder. And then you go left, or you go right and I'll go left. And I initially thought I saw it, and it looked like a fawn or a deer in the ditch. So I said, I think I see something, but then I come up, and it was the man. And he is not in good, he's dead. And so I, quite frankly, stammered, Tim, something to that effect, and trying to just get his attention to have him come up, and I kind of maybe run towards him a little bit, and Tim, you need to come see this. And I don't think I told him what I'd found. You need to come here and see it. And then he saw it. And I said to him next, well, we need to go find the sheriff again.
Still with us, civil rights attorney James DeSimone is in Los Angeles. James, you watched this part of the explanation here in the police interview. The attorney general seems like he did everything right. He called 911, gave his documents, and he just thought he hit a deer. Anything at this point, we'll hear more in a bit, that would raise any red flags?
Well, Well, not necessarily in the interview or not necessarily in his actions after. I mean, he calls 911 as is his responsible thing to do. But as we may find out, what caused the accident? I mean, he killed a man. The man came through his windshield, and he acts as if he knows nothing about this. Perhaps the facts are not congruent with what he's telling the investigators right now. But you're right. I mean, he does the responsible thing, and he even goes back the next day to see if he can locate exactly who he hit in the light of day. So, but there's more.
Yeah, and from that end point, would you go back if you hit a deer? I don't know that I'd necessarily go back to find the deer. Maybe, I guess. I would, but I'm not sure. But he does go back, and that's part of the story. He goes back with his friend, an associate, Tim, and then that's when he discovers the body, which we're going to find out. And then we're going to see when we come back. We're going to take a break here, but when we come back, we're going to see the rest of that interview, and we're going to see the confrontation that happens after the investigators go and do a little bit of investigating and fact-checking, and then they bring what they found back to the Attorney General and watch his reaction. That's coming up. Stay with us. Attorneys for South Dakota Attorney General Jason Ravnsborg entered a plea this morning into the record in the case against their client. Ravnsborg was facing traffic charges, 2 counts, from a crash last year when he hit and killed a man who was walking along a rural highway. We took a look at his initial police interview on this. Now let's take a look at a second interview conducted with the Attorney General. This time, the investigators, including the lead investigator, confront him with the evidence that they have gathered.
How much time did you spend looking for your insurance card?
The insurance card took a little longer. I mean, the other was right there. And then, because I remember I looked at it, and then it was not the right one. It's like the year behind. Sure. And I looked at it, and that wasn't right, and I looked at it a little while longer, and I took it back to the sheriff, and then I said, I don't got the right one, I mean, I think as he was writing it out, and he says, hell, nobody's got the right one. Usually I got about 5 of them in the car. He said something to that effect.
Sure. And that was on the visor, the other was in the glove box?
The glove box, yes.
Did you have to take things out of the glove box?
Yes, I had to move stuff around, yes.
Okay.
Yes.
Did you notice anything on the passenger side while you were doing that?
Just glass. I mean, I was staying away from the glass, I guess.
Okay.
I mean, I didn't spend a lot of time.
So when you're doing that, are you leaning over the console?
Yes, from the driver's door, leaning over, yes.
Okay. So you can kind of see in the glove box, and
right.
Which is already popped open.
It's already popped open, yes.
Okay.
Yes.
So, did you see the glasses right next to that?
I did not.
Okay.
You showed me the glasses the first time. The first time.
They're Joe's glasses.
I wondered about that.
So that means his face came through your windshield. It's a tough thing.
Oh. I was thinking that his face did not come through because there would have been blood. I thought there'd been blood everywhere then. Now, I've thought about it.
Yeah, and you've had time. Right. His glasses are right there, Jason. Those are Joe's.
I did not see the glasses until you showed it.
Mm-hmm. Sure. Oh. So the only way for them to get there is through the windshield. At the impact, did you look over and see anything?
I did not see anything. I mean, it was, again, I then was looking to get it to the side. I did not see anything. No, absolutely not. It shattered, and I probably cringed or something, but I was just trying to get it to the side. I did not see him. I did not know there was a human until the next day.
Okay, so when the glasses are in there, it's like his lenses, and we have a witness. We've talked to witnesses that actually had seen him out there as well.
I did not see those glasses.
One of the other things that we know, Jason, is you weren't in the middle of the road. You were on the shoulder. And I know it happens fast because it's happened to me. We have 3 people putting him next to the grass. So we knew something was happening. I mean, you're a smart man. You know, Joe and I have done this job a long time. We know what the evidence is going to show us, what the evidence does show us.
I don't remember. I remember being in the road, but you know, I guess you'll show me what the evidence shows. But
Yeah. So part of the evidence that is really convincing is there is bone scrape on the inside of the rumble bars, and that's where his leg was likely broke. That's where the pieces were at.
So how did he get farther down the road? I mean, did he ride? How did that?
His face was in your windshield, Jason. Think about that. I got another question for you. Okay. Did you see the flashlight he was carrying?
No.
Ever? When you walked back to town?
No flashlight.
It was pitch dark out there.
Right.
And with it being pitch dark, we went out and tested it.
Okay.
We picked up the flashlight.
Right. Okay.
The flashlight was still on when Joe and I got to the scene.
Okay.
It had not been touched.
Uh-huh.
We picked it up and the light is still on.
Okay.
We talked to a witness that had just seen the light, had seen him walking with the light.
Okay.
After the crash, did you see that light in the dark? Because it's pitch dark. If there's something glowing,
right,
it would make sense for you to see it.
Right. I did not see any light, no.
Are you certain?
I am absolutely certain.
And Jason Ravensborg, the Attorney General in South Dakota, he still holds that position. And he was sentenced within the hour, and he was sentenced to no jail time, $1,000 in fines, 2 $500 fines. The victim in this case, Joseph Boevers, his family was there at the hearing today, the sentencing, but the Attorney General was not. His attorneys were there representing him. He did not have to attend. They were frustrated, told the Associated Press that they waited all this time and did not have the opportunity to confront him. He left our brother in the ditch for 12 hours. It is inexcusable. He used his power to get away with this. James DeSimone is with us. James, you look at that second half of the interview, and it's when this story starts to crumble a bit. The victim's glasses in the vehicle, meaning his face, as the detective pointed out, went through the windshield. And then maybe more importantly, he was not in the center of the road like he claimed he was. And they didn't, the sheriff and him didn't see a flashlight on. What stands out to you the most when watching the Attorney General, the top prosecutor in the state, being questioned?
2 systems of justice in the United States of America, and this is a prime example of it. I mean, not only is this a white man, he's a person in power, Attorney General, but he is giving false statements to these police officers when he says he thinks it's a deer. This man's head went through the windshield such that the glasses ended up on his front passenger seat. There is no way, if he had been paying attention, that he could not realize that this was a man. And then we look at how did the man get into the ditch when he went through the windshield. That must have meant that he was kind of pushed over into the ditch, and he was hoping that by not having the sheriff not see the man that evening, he wouldn't be tested for alcohol or anything else that would impair him. We know he was on his cell phone. We know he was driving in the shoulder. We know that's reckless driving. We know it resulted in the death of a man. $1,000? no jail time. The family is properly outraged. This is an abomination of justice, in my opinion.
Yeah, if you think you switch the tables, he is the top prosecutor in the state. If you look back, I'm sure you'll find somebody in the state of North Dakota or South Dakota who is doing some jail time for the exact same set of circumstances. You could pull the alcohol out because he was tested for alcohol 18 hours later. Obviously, there was nothing there in the system. Even if he wasn't under the influence, it's reckless driving. He's on the shoulder. They were able to prove that. And yeah, this was the charge. To your point, this is an issue, is it not? This sort of two-system we've been working with for centuries.
It really is, and it just undermines everyone's confidence in the judicial system to see someone get off like this. I mean, he didn't even appear in court, such that, at the very least, if this man was sincere, apologize to the family. I mean, come there, be a man, be a person. You've taken this family's loved one, and come to court and acknowledge that what you did, maintain it was an accident, but apologize for your actions. He doesn't have to do any of that. He just gets a fine and has his attorney show up in court. It's a sad day for justice when someone can, literally get away here with what appears to be manslaughter.
Yeah, and again, the Attorney General is still the Attorney General in the state of South Dakota. There have been calls for him to resign. He has refused to do so. Of course, there'll be another election at some point, and we'll see what happens there. But bottom line is he's still the Attorney General, didn't have to go to court, and he has to pay $1,000. And then that's it, do some community service. James DeSimone, thank you, as always, for your expertise and helping us through this last hour. We're going to step aside and take a break as we approach the top of the hour. We have Chanley Painter in Los Angeles County. Julia Janae is in Brooklyn, New York, covering trials on both coasts. We'll have updates from both of them. We're expecting Robert Durst back on the stand in just about 5 minutes. As soon as he's back on the stand, we'll get you in for more live testimony. When we return, Julie Grant's going to be here. You are watching Court TV, your front row seat to justice.